For those of you who don't know me, my name is Ira Smith, President of Ira Smith Trustee and Receiver Inc. First, I hope that you and your family are safe, healthy, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver Inc. is fully operational. We are holding all meetings and consultations either over telephone or video conference. Both Brandon Smith and myself are available at any time to answer any questions you may have, and we would love to hear from you. Today's Brandon's blog is about a very, very interesting application to court that's coming up soon in Manitoba, and it really has to do with, can a bankruptcy filing be annulled? Now, I know you will get value out of this video and blog, so I hope you can watch it until the end. Bankruptcy means that either the person or company has filed an assignment in bankruptcy, or the court has made a bankruptcy order against the person or the company. The purpose of the bankruptcy is not to have it annulled. Rather, it is for the insolvent person to be able to restructure their financial affairs, get relief from their debts, and come back into society fresh and clean and able to start over again. The system assumes certain things, that the person filing for bankruptcy or being placed into bankruptcy will make full disclosure to his or her licensed insolvency trustee so that the bankruptcy administration can be properly done. The case that I'm talking about is one of a fellow named Stanley Frank Ostrovsky. Now, Mr. Ostrovsky was convicted in court in May 1987 before a jury of first-degree murder, and he was sentenced to jail for life. While in jail, he was running a side business because in 1992, he was found guilty of possession of cocaine for the purposes of trafficking. He was sentenced to 15 years in prison, but concurrent with his life sentence. Well, Mr. Ostrovsky served 23 years, 2 months, and 24 days in prison. He was released from jail on December 18, 2009. 5 years later, in 2014, then Federal Justice Minister Peter MacKay asked Manitoba's Court of Appeal to review his case. The Justice Minister believed that there was a miscarriage of justice with respect to the murder conviction. The Manitoba Court of Appeal reviewed it and agreed that there was a miscarriage of justice because 2 pieces of information was not divulged by the police to the Crown and therefore not to the defense. Now, the Manitoba Court of Appeal did not acquit Mr. Ostrovsky because they felt even if those 2 pieces of information were divulged, there was sufficient evidence with or without those 2 pieces of information to convict him. So rather, they just vacated the finding of guilt and stayed any further proceedings. Then, in 2019, Mr. Ostrovsky filed for bankruptcy. And this was his second bankruptcy. He listed $251 in assets and some $259,000 in bankruptcy. In June 2020, Mr. Ostrovsky swore an affidavit, which was filed in the Manitoba court as part of his application to court to annul his bankruptcy. So the question is, can a court annul a bankruptcy? The answer is yes. Section 181(1) of the Bankruptcy and Insolvency Act does give the court that authority. But exercising that authority is discretionary. It's not automatic. And there have been many cases, which I will talk about shortly, as to the reasons why a court can or could not annul a bankruptcy. But first, let's look at Mr. Ostrovsky's affidavit to see what reasons he says. He gives two reasons. The first being that he has a realistic chance of receiving sufficient compensation to be able to settle my debts with creditors in a manner that would be more advantageous to the creditors than if I pursue bankruptcy. He doesn't say that he will get enough to pay them out in full, just that he will be able to settle his debts. The second reason is that he's advised by his lawyer that his trustee is not objecting to his trying to seek a court order to an annulment. Why would the trustee object? The trustee doesn't have to file any material. The trustee doesn't have to go to court. The bankrupt is on his own. Those are the two reasons. As you will see shortly from the information I'm going to give you, I consider those reasons to be somewhere between very weak and lame. I'm not so sure if that's his only evidence that the court will grant his request for an annulment. An annulment is more than just canceling the bankruptcy. It's canceling the bankruptcy to the point where it fully erases it, as if the bankruptcy never happened. As I mentioned, the Bankruptcy and Insolvency Act does give the court discretion to annul a bankruptcy, but here's what the Act says. If, in the opinion of the court, a bankruptcy order ought not to have been made, or an assignment ought not to have been filed, the court may by order annul the bankruptcy. So the question is, should the bankruptcy have been filed? There are examples of cases where a request was made and the assignment in bankruptcy was not annulled. The court refused the request to annul the bankruptcy. So what are those examples? The examples are the sole purpose of the bankruptcy was to rearrange the priorities of certain creditors. That's allowed. There's no need to annul a bankruptcy for that reason. A bankruptcy was done to defeat the enforcement rights of a judgment creditor. Perfectly fine. The sworn statement of affairs left out the name and amount of a creditor. Well, that happens all the time. It's not a reason to annul a bankruptcy. The bankrupt, when coming to the trustee to file, is obviously under a lot of emotional stress. It's quite possible that they forget to name one or two creditors. The debtor had no assets. Well, many times that is the case in a bankruptcy. And the debtor was insolvent, but didn't bring the application to annul the bankruptcy until 4 months after filing the assignment in bankruptcy. That's a very important one because the case that decision came from was a Manitoba case. The bankrupt came to court 4 months after filing her assignment in bankruptcy, saying although she filled out the paperwork, the trustee made a mistake in actually doing the filing. The court held that if such a mistake was really made, and based on the evidence, the court wasn't sure that such a mistake was made, the court said the bankrupt should have come right away. So those are reasons why the court refused to annul a bankruptcy. Here are some reasons why the court agreed to annul a bankruptcy. The first case, the assignment in bankruptcy was completed and was to be held in escrow while the debtor negotiated with all of his creditors. And only if he could not reach satisfactory arrangements with his creditors was the assignment in bankruptcy to be used. Well, the debtor did make sufficient arrangements with all his creditors, and then by mistake, the assignment in bankruptcy was filed. In that case, the court agreed the assignment ought not to have been filed and annulled the bankruptcy. There could be cases where the bankruptcy was of no benefit to the creditors. Perhaps if there was only a few creditors and they got judgment and there were sufficient assets, they could seize assets under their judgment and get paid in full. By invoking the bankruptcy, there would be costs of administration, and now the creditors would not get paid as much as outside of bankruptcy. So in that case, the bankruptcy was annulled. The debtor was restrained by a court order from dealing with any of his assets without giving his estranged wife 7 days clear notice. By filing the assignment in bankruptcy, by not giving his wife any notice, then he was dealing with his assets in contravention of the matrimonial court order. So in that case, the bankruptcy was annulled. There was a joint assignment by both husband and wife. Joint assignments are allowed, but there has to be a commonality of debts. In this case, most of the debts were business debts of the husband's sole proprietorship business. The wife was not a partner, therefore they were not her debts. The court annulled that bankruptcy, the joint assignment, but the husband could be free to file an assignment in bankruptcy on his own. A bankruptcy assignment was once actually purportedly filed by an infant. Obviously, an infant cannot take legal action, and so that bankruptcy assignment was annulled by the court. The husband filed an assignment in bankruptcy trying to disgorge himself of all his assets while he was in a bitter matrimonial dispute with his estranged wife. The court looked at that and said it was an improper use and annulled the bankruptcy. In a court-appointed receivership my firm was involved in, the directors of the company, while the receivership was ongoing, met to resolve to file an assignment in bankruptcy and filed the assignment in bankruptcy for the companies that were already in a court-appointed receivership. The court looked at that and said it was a misuse and there was no need to file the assignment because the assets of the company and dealing with the creditors of the company was already under the supervision of the court. In this case, Mr. Ostrowski just says it will be better for him to settle with the creditors once he gets his money. Well, in our view, that is not a sufficient reason to annul the bankruptcy. But there is a way that he can annul the bankruptcy, and it's right in the Bankruptcy and Insolvency Act. And I would be shocked if the court doesn't tell him this. The way he can do it is by filing a proposal. If his debts are truly more than $250,000, then he can file a Part 3 Division 1 restructuring proposal. If his debts are less than $250,000, then he can file a consumer proposal. The proposal will simply read something like, I am about to have my lawyer issue a claim against the province of Manitoba, the police, the Attorney General, all sorts of other people, and I'm going to claim $16 million. And if I'm successful in getting more than $259,000, all you creditors are going to get paid out in full. That is my proposal to you. And whatever I get, the first amount necessary to pay all my creditors in full will go to the trustee, and then the rest goes to me. That's the way to do it. Why wouldn't the creditors accept that kind of proposal? Once the court approves the proposal, the Bankruptcy Act says his bankruptcy is annulled. All he needs to do to start that proposal process is get the permission of the inspectors in his bankruptcy administration, if any were appointed. If there aren't any, he doesn't even then need to go to court to start the proposal process. He can have his bankruptcy annulled by doing that kind of proposal very quickly. The other way, which really doesn't annul his bankruptcy, but if he's successful, the $16 million, or however much he ends up actually getting, will go to his trustee in bankruptcy. But he will be kept in bankruptcy until that happens. Then the trustee will be able to pay all the creditors in full with interest, the way the Bankruptcy Act says the trustee has to. The trustee will have enough money to pay all the costs of the bankruptcy administration. And then the Bankruptcy Act says the surplus money the trustee doesn't need goes to the bankrupt. And then Mr. Ostrowski will have the rest of his money and his bankruptcy discharge, but it will never be annulled. So if he really wants to annul his bankruptcy, the real way to do it is to file the kind of proposal that I've mentioned, and he can be out of bankruptcy, have his bankruptcy annulled extremely quickly. I hope you enjoyed this video, and I hope you got good information and value from it. The Ira Smith team is fully operational, and we are able to assist you and answer any questions you might have and talk about any issues you may wish to talk about, either by telephone or by video chat. Shoot either myself or Brandon Smith a message or give us a call. We would love to hear from you. In the meantime, we hope that you and your family remains healthy, safe, and secure.